Oh, hi, Scott. You're here. How are you? You're still muted? I'm going to make you a co-host. And I'm going to make Joe a co-host as well. There we go. I cannot hear you.
All right, you should be able to hear me now.
There you go. Now you're good. Hi. Nice to see you.
It's good to see you. Thank
Good.
you.
Good. I've opened it up so people can start coming in. And I'll do a real brief opening intro of Joe, add in a few housekeeping things for people, and then turn it over to Joe. He is here. He looks like he has disappeared himself for a moment. So are you going to stay with us the entire time, Scott? Or
Yes, I am.
Very good.
I'm going to shut my door so my Labrador doesn't run in and start throwing balls at me.
There you go. I probably have a cat somewhere who's going to be sticking her tail in my face in a few minutes. Hello, everybody, and welcome to our program today. My name is Linda Warren Seeley, and I am the director of the section of dispute resolution. I will be your staff host today. This is a keynote program with Joe Al-Khayat of Resolve Disputes Online. The name of his keynote presentation is A Practical Approach to ODR for Practitioners and the Courts. Joining Joe today will be Mr. Scott Bade, who is the president and product visionary of US-based ImageSoft and Canada. ImageSoft has been in business for 25 years and focuses on helping courts and attorneys use technology to improve process efficiency. So before we start, I want to remind you that you can access all of the program information in the Tech Expo Hub. I will place in the chat a link to the hub so that you can check that out anytime. We encourage you to submit questions for the presenters anytime during the program using the Q&A button in the Zoom toolbar. And I believe our presenters will have a Q&A period at the end of this program. If you need technical support during the program, please click the tech support link in the chat window for Zoom, or you can send me, Linda Seeley, a chat message with your problem. Please remember that this program is being recorded. You will be able to access the recording probably within the next week or two if you need to go back and take a look at it in the future. So I want to go ahead and welcome Joe, who is here, and Scott. Joe is the co-founder of RDO, a specialist dispute tech company, which provides technology to courts, mediators, arbitrators, and tribunals around the world. Again, his presentation is A Practical Approach to ODR for Practitioners and the Courts. So thank you, everybody. And Joe, you may begin.
Thank you so much, Linda, for having us. It's been a real pleasure this week being part of the ABA conference. I hope many of you have been able to make some of the sessions. There's been some fantastic sessions that have been put on, and we're really looking forward to sharing with you some of the information we've got for our keynote session, and delighted to welcome Scott, who will be taking us through some really interesting insights when it comes to court technology and online dispute resolution towards the end of the session. Now, allow me to share my screen with folks and take you through what we've got planned for the course of the session today. In terms of the structure, what we thought we'd do, for some of you who are new to Resolve Disputes Online, we thought we'd give a quick overview about RDO and why it started. an introduction to online dispute resolution and where we're at now. I know there'll be some folks in this conference who are old hacks of online dispute resolution, and will be able to know the content I'm about to speak of, probably backwards, but there'll also be some who are quite new to this, and particularly since COVID. Many folks will have been new to online dispute resolution, and certain practitioners may be doing it for the first time. So we'll go into a little bit of detail about that, leading on to specifically mediation practice with online dispute resolution. We'll start moving on now to the larger end of town after we've looked at mediation with the courts, looking at some success and how we measure that, and some key KPIs that we tend to see across the globe when it comes to online dispute resolution projects. And then we'll be going a little bit deeper with Scott, who's joining us from ImageSoft, talking about online dispute resolution in the courts specifically, and talking about some of the current challenges and perhaps where we might be headed in the next phase of ODR in the court services. But for those of you who are new to online dispute resolution, you won't be new to the problem that we're trying to solve as a collective. And it is the vast amounts of people that live outside of the shelter of the law, and it is those jurisdictions where the cost of taking a civil case to trial is expensive, and the time it takes to take a civil dispute to closure is very, very considerable and very long. And the big 5 jurisdictions, and the US will obviously be part of those, we tend to have quite a low or a modest satisfaction rate of court processes, but we tend to have quite a high impact on mental health, jobs and relationships. So that's the macro problem that's really driving the likes of the ABA to put on some of these tech schedules and conferences, and why people like RDO exist, because of this chronic problem. And if we were to maybe get a bit more logistical about how this works, between maybe the mediators, as you folks might be, or the courts, and the end user, who could be a business or a consumer in the US or anywhere in the world, there's often a labyrinth of complexity that sits between those two entities. And the idea behind RDO, for those of you who are new to the concept of RDO and what it does, we essentially license our technology to empower folks like mediators and the courts to be able to do what they do better. And the tool that we like to give is something that can be used in a variety of jurisdictions, as you'll hear about during the course of the session. In terms of who we are as our background, like many of you on this call, we are a team of international lawyers and mediators, arbitrators. We have judges and UN justice leaders on our leadership team, but we've also got our technologists. And I think between us, we've got about 100 years of cumulative dispute resolution experience from 6 jurisdictions. And the academy that's been running for 3 years has trained many administrators and mediators from all over the world in ODR. For those of you who are really interested in technology, and this is something that we can talk about perhaps in another session, but the idea of blockchain and smart contract mediation settlements are things that we were modeling just over 4 years ago. And with funding of the UK government, we're developing AI mediator technology, where it's possible for those very, very high volume, low complexity matters that parties could solve cases without a human mediator. But don't worry, you won't lose your jobs just yet. There's a long way to go in this type of technology, but interesting to see how the journey of ODR is starting to move. In terms of my background in online dispute resolution, I started mediating online about 13 years ago using Skype, and that was really my first introduction as a practitioner to online mediation and what the possibilities of ODR was. And since that period, and prior to that, ODR as a definition seems to have shifted quite a bit. We tend to settle on a more practical definition nowadays, referring to the use of technology to assist with dispute resolution. And it primarily involves the use of tech when it comes to negotiation, mediation, and arbitration. So it typically tends to be the ADR components that have got most of the attention when it comes to online dispute resolution, and it was the e-commerce platforms that were fearful that their users may well have to use small claims courts around different parts of the world and cross-jurisdiction issues that started to create ODR within those e-commerce platforms back in the 90s. And many of the established jurisdictions are now following suit, and we'll be talking very briefly about what some of those jurisdictions are doing at this moment in time. We know that ODR leverages the advantages of modern technology, which we associate with convenience and accessibility. And the tool that we're using now is often a tool that's used by mediators, and we'll be coming on to that later on in the presentation. But other examples of technology might be case triaging tools, it might be file sharing, it might be algorithms or AI, intelligent automation as well, which is important, and then obviously the communications tools that we tend to see. Now, since COVID, we've seen a bit of a rise in what we describe as online trial tech, which has become a bit of an added component to the classic components of online dispute resolution that we've seen typically in ADR. This facet of trial tech seems to have become quite important, and typically that has involved video conferencing. But it's getting slightly more complex and deeper as time is progressing. But one of the questions that we want to pose as a practical consideration is ODR becoming a redundant definition, or at least is it becoming too broad? And if we compare the way that industries and skill sets have evolved over the past 5 or 10 years, things like engineering, medicine, architecture, skill sets such as project management that of course are across a multitude of different industries, these folks don't refer to an aspect of engineering where they're using technology as online engineering, or an architect that's drawing up the plans of a particular construction project wouldn't say that they're doing online architecture drawing. A project manager that is managing a construction project or even a tech project wouldn't refer to the use of certain tools as online project management. Banking is a great example, because at one stage we would hear about online banking as being almost a divisible or a separate entity or service when it comes to banking. But what we're seeing across many industries is just that it's simply implicit in that industry or that skill set that technology is going to be used. So the question that we may starting to crop up over the next 2 to 3 years is, will dispute resolution just implicitly mean ODR? And will this distinction that we have between online dispute resolution, alternative dispute resolution, appropriate dispute resolution, as our Singaporean friends call it, will this distinction start fading away? Or alternatively, will this rather broad brush definition of ODR start becoming a lot more focused? Because we're talking about online trial tech, we might start talking about ADR tech. And within those two broad categories, we might actually start looking at a subset of AI or blockchain or other facets of technology that sit within some of those groupings. Case triage technology, those may sit inside a broader category of ADR technology. So it's been fascinating seeing the evolution of this industry even over the past 5 years, and more considerably perhaps over the past 6 months, as things have got a lot more granular and a lot more detailed in terms of some of the technology. But where are we now in relation to online dispute resolution? Well, there's projects globally across courts and tribunals. We're fortunate enough to be involved in quite a few government projects in various jurisdictions, including the work that's being done by Law Tech UK and Tech Nation, which is working with the UK government on their SME ODR platform. There's obviously Her Majesty's Courts and Tribunal Service, which is a $2 billion project that's going on at the moment. In the US, there's a multitude of projects that are going on across numerous states. And the theme that we're seeing in the courts still is ODR's application in the high volume repetitive caseloads. Some would have said that that's the sweet spot of online dispute resolution. But what we've noticed with particularly COVID is ADR practitioners and ADR centers, there's a growing adoption there. And whereas historically folks used to say that ODR shines with high volume and repetitive and low complexity caseloads, what we've seen is what we at RDO have always suspected, which is that good ODR technology can also satisfy maybe the lower volumes and more specialist caseloads. And that's certainly been the case when it comes to ADR practitioners and ADR centers that we're working with. And to give you an insight of the geographies that we're dealing with, there's projects in the public and the private sector that RDO are dealing with in Australia, in Thailand, in Africa, in the UK, as we've mentioned, Canada, and in the US. And there's many more jurisdictions that are also showing a lot of traction in wanting to do projects, whether it's with their courts or whether it's with their public sector ADR centers. In terms of what we've noticed is the acceleration that's occurred due to the pandemic, and that's mainly been video, which we at RDO see as a smaller component of online dispute resolution. To many practitioners since COVID, video has been the ODR tool. It has been synonymous with online dispute resolution, but that's not how we see the real value-added facets of technology in ODR. But nevertheless, it's been an acceleration due to that. We also have noticed, particularly when we started mediating online, that using video for mediation was very much an experiment. And it was one of those things that if you fancied it and maybe there was a novelty about your case, you might do it. But now it's more so a piece of necessity. Going back to those industries and experts and skill sets we were talking about in the previous slide, it's like being an architect and saying that you're not going to be interested in using sophisticated CAD or planning software to design the architecture of your building. It is something that is in your toolkit now that you need to start using. So what we've noticed is ODR or online videos for mediations is starting to become a necessity of practice. The other thing that we've noticed is when we used to speak at events on online dispute resolution, you'd sometimes need to talk to people about the advantages of ODR. It seems we're past that now. It seems it's pretty self-evident as to what some of these tools can do. And without needing, therefore, to focus on what's good about ODR, it's not a question of whether you're going to do it, it's a question of how you're going to do it and what that looks like. And Scott will probably go into that in a bit more detail as we're talking about some of the things that courts are looking at, particularly from a US and Canada point of view. So this shift has been really fascinating, where we no longer have to perhaps talk about some of the advantages of ODR because they just seem so obvious. And the final consideration about where we are is, will ODR uptake reduce when normality returns, whatever that normality looks like? We suspect there's now been an irreversible paradigm shift when it comes to dispute resolution. And if one was to think of the toolkit that was in the dispute resolver's toolbox, the compartment that we would have looked at for ODR was probably a lot smaller back then, but now it's getting considerably larger. And we suspect that part of the toolbox is going to get larger and larger, which is why it's important that great tools are going to be available for mediators and arbitrators and also the larger end of town, such as courts, to resolve some of their caseload. The challenges of ODR that one used to spend quite a bit of time having to address, some of them are obviously still very relevant. The ability to build trust and rapport as a mediator can be challenging using technology. We have our videos on for the purposes of this conference, so you can see me. It's better than just hearing my voice, but it's not quite the same as if I was standing in a conference room in front of you and you could see the whites of my eyes. Nevertheless, Technology is getting better, and you can still see detail on my face. You can still see the way that I'm talking. So those lack of nonverbal cues that we used to get more and more with low resolution videos and the like appear to be mitigated. Internet connectivity and those issues, even 12 years ago, there were huge problems when we would be using tools like Skype to mediate online because folks didn't have the internet connections back then, and that's really changing. The suitability of technology. Technology is moving at a rapid pace. The demands of technology is greater than ever before. We have scenarios where the UI UX standards that we expect from tools are extremely high, whereas way back when, maybe those standards weren't quite as expected from the end user. So a lot of technology now is a lot more suitable and a lot more user-friendly. The challenges that used to get thrown at myself, at colleagues at RDO used to be, well, online mediation wasn't confidential, and the old scenario that would be questioned at every conference we'd speak at would be, what are you going to do when the plaintiff or the claimant starts recording parts of the session? Surely they can do that because it's video, and you wouldn't know as the mediator that they're doing that. And mediation is a without prejudice process, as many of you will know on this call. How are you going to mitigate that? And doesn't technology play into that risk? Now, the answer to that question then and now is that one will simply rely on the confidentiality clauses that sit within a mediation process. So many of the issues that used to be raised about online dispute resolution, like it was some new experience and it had a new set of rules that would govern it, often the answers would lie in best practice of what would happen face to face. And again, over this last decade, we've noticed a real acceptance in terms of being able to move on perhaps from some of those concerns, which are perfectly legitimate concerns, to understanding how the existing pre-mediation agreement or the existing ways that one would deal with confidentiality points that might arise in a mediation. But there is concerns relating to data. Where is the data kept? If you're using certain technologies, such as the one that we're using now, how can you guarantee that the data is going to be staying in the jurisdiction that your client's based, and perhaps you as an attorney, how would you sense check that point? But overall, what we've noticed is probably the weight of these points, that the weight these points had even a few years ago appears to be diminishing. And that's because of the fact that ADR has evolved so much, and the distinction between ODR and ADR is getting much more blurry. There is not that distinction, as I mentioned at the beginning of this session. And we need to meet disputants where they are, which is online. And the great thing about ODR, as many of you will know who are listening to this call, it's been that great product that has promised so much, both from a practitioner and an end user point of view. In the US, in the UK, in Australia, in Asian jurisdictions, ADR was the thing that back in the early 90s was going to be the thing that would bust some of the backlogs. But it never really took off, and there are a whole variety of reasons for that. But that appears to be changing, not least because many court rules now have a mandatory subscription or requirement to be able to undertake a pre-action process, like a form of alternative dispute resolution. And when you start building technology into that, that's when things start to get really, really exciting. So for those folks who are on the call who do mediate, or any attorneys who take part in mediations, whether you're in the US or in other jurisdictions, you can typically distill the process down to a number of steps. And we've distilled it down to 11 steps as to what a face-to-face mediation might look like, a live face-to-face mediation. So you've got the booking process that would typically take place on a phone, entering details there, sending invoices, sending terms of services, getting that venue chosen, getting it booked, getting the documents requested, usually by email or phone. Parties, as I used to find, sending documents in a rather piecemeal or last-minute fashion. You've then got the travel, the venue setup, deciding who goes in which rooms can even be a bone of contention. Who gets the room with the window? Who gets the room with the coffee machine? Whatever it might be, those processes will inevitably take their time. Checking everyone has evidence and the relevant documents. Doing the mediator spiel of, I'm the mediator, I'm not a judge, the process is without prejudice, setting the ground rules, all those things all had to take place. And then the shuttling between the various rooms that you'd typically do with a piece of paper, or perhaps more typically now with an iPad, or using a telephone to do that process. And then drawing up a settlement, getting the settlement drawn up, usually by hand, getting someone to type it, getting it printed, getting it signed, getting it scanned, and getting it emailed. Do we really need those 11 steps? I don't think we do. And that's been one of the interesting paradigm shifts that we've had with online mediation, the fact that you can conflate or summarize a lot of these steps, registering and payment integrations, the document upload and sharing can be done with one click. The ability to do online or asynchronous introductions or ground rules, and not necessarily having to do the traditional method, have all been things that have been hugely advantageous. And you've also got the settlement process where you can get that drawn up online and digitally signed. And all of these things are supported by the RDO technology. Now, what are the advantages of online mediation besides video? Well, we'll deal with these really briefly. It's time and convenience, it's flexibility, it's the cooling distance, the reduced risk of intimidation and the like with certain types of caseloads. Asynchronous communications are able to avoid scheduling issues. And the technology almost becomes like the co-mediator or the co-party that is able to send reminders and even auto-generate documents, as is the case with RDO. Now, since COVID, there is a question that is posed by many a practitioner, and many legal journals have said, you know, mediation has zoomed since COVID-19. And that is largely because many industries have zoomed. Zoom have successfully captured, along with many other video conferencing platforms, a real need to start using this type of technology. But when we look at Zoom as a mediation tool, despite its advantages, is it a starting point of ODR, or does it encapsulate an end-to-end mediation process? We say it's at its highest a starting point. And there will be now an irreversible paradigm shift towards using technology. And for those folks who have started to use Zoom in mediations or other video tools, now might be a helpful time to start thinking about where the next generation of mediation tools is going to come. And obviously Linda and the team have put together a really rich amount of content for this program. And you'll see some examples of that technology on show now. But let me give you a high-level summary of the sorts of things that you do on Zoom and the sorts of things that you might do with an ODR tool, like resolve disputes online. So Zoom is fantastic for those communicating in real time or one-to-one sessions, but you can also do that in a tool like RDO. It's great for scheduling appointments where you share the case link. You can schedule appointments with generally most RDO tools. But then there's a huge plethora of facets of technology that Zoom, obviously being a generic video tool, will not be able to satisfy. And the ability to communicate asynchronously as a mediator is pretty fundamental. The ability for folks in different time zones to fit dispute resolution in around other commitments, but keep the case moving, is a huge piece of flexibility when it comes to online dispute resolution, and an asynchronous task flows or workflows and communications are one of those. The ability to retain logs of communications as well. So when a video session finishes, you don't just lose that information. You're able to keep a log of that against a case file. Receiving in-platform notifications of case activity, receiving email notifications of case activity, case management tools and case progression, the ability to digitally sign documents, the ability to create task-driven workflows for your clients as you're mediating. Zoom does have the ability to share, and I've been fairly generous in my interpretation here, in terms of the evidence sharing in real time. Zoom does have that capability to the degree that one can share their screen, as I'm doing now, but it won't have that ability to audit and track the evidence that's shared on a case in real time. And it certainly won't have the ability to share evidence in an asynchronous manner.
Joe?
Joe, we've lost your audio for some reason. I don't see that in the toolbar.
You guys hear me now?
There we
Excuse
go.
me.
Yep,
Testing
you're
1,
back.
2, 3.
You're back, Joe.
There we go. There we go. Some of the perils, Linda and Scott, of online communication. So how do we know if ODR is working? That's the section that I was going to come to. And one of them is, can you hear the mediator? But perhaps more strategically, what should we be saying? Country specific, culture specific, enforcement, opting in, opting out, satisfaction rates, case volumes, backlog, group reductions. Let me just deal with just a couple of these at a high level. We're fortunate enough to sit on the APEC group when it comes to online dispute resolution. And in Asia and in that region, there's a multitude of different countries that are dealing with online dispute resolution projects. One of the challenges that one sees across different countries is just simply how they approach it. So the Chinese have been extremely successful in building out very quickly a lot of technology when it comes to online dispute resolution. Their internet court in Hangzhou has been viewed as a great success from a tech point of view. But one of the things that court did was insist that people use it. In other words, if you wanted to use a traditional process, that was no longer available to you. Now, some of the technologists who sit in this field might say, well, that's good because we know technology is the only way forward, and we have to be making sure that we're encouraging folks to be using it. We approach it from probably a more principled rule of law basis, where we should not be denying folks access to courts. We shouldn't be saying the physical courtroom is no more. And there'll be certain jurisdictions that will be moving in that direction. We think there's a place for a hybrid model. And as countries start doing more ODR projects, I think some of those cultural nuances that exist among some of the jurisdictions will start to play out. The other piece is enforcement. So one of the challenges that many jurisdictions have is the ability to enforce judgments. So it doesn't matter if one has a really neat way of getting to a judgment or getting to an agreement. The challenge that would follow any alternative dispute resolution process, whether we're talking about a negotiated contract in a negotiation process or in a mediation process, if a party doesn't abide by that and you sue for breach of contract, or maybe it's been incorporated in some other contract, the ability to enforce those damages is still a problem. If your enforcement mechanisms in your court also are modernized. Now, going back to our friends in China, they have a system where they have the ability to take money out of a bank account in certain jurisdictions. So enforcement is never a problem. Again, would some of the English-speaking jurisdictions be happy giving access to bank accounts? Where we can see the effortless integration of things like blockchain where a smart contract settlement will instantly activate and take money for damages from someone's bank account. Will we be open-minded to that? Or is there a more careful balance that's needed? Those are some of the cultural things and some of the tech questions that we'll need to consider when trying to solve some of those problems. The opt-in, opt-out process, we see that in the US, where folks are saying that the presumption is you go online unless there's a compelling circumstance. That appears to be a model that's working well. But ultimately, these are the sorts of questions we should be asking as ADR professionals and as governments to make sure that we're moving in the right direction. Because ultimately, what's got to be at the center of any of these digitization programs is the rule of law. You know, they are the principles of Magna Carta that were set out so many years ago, 800 years ago, that to no man or to no person should we deny justice. And if we insist that folks have to go down a certain road or route in relation to their dispute resolution process without considering nuances like natural justice, these are the questions we need to be asking and making sure that we remain some of the leading jurisdictions in the world. But these will be great questions that we start to think about as time starts to progress. And when I talk about user-centric tools or getting customer feedback, making sure that the tools that we're using are actually built with feedback questionnaires like the RDO tool, where we can begin to really capture data, to create tools that are user-centric, to create tools that are built around the user. Courts have been criticized as being these Victorian, if not older, institutions that were built around the judges and the lawyers. Maybe this is our chance to create something that really does sit around the end user. So some of the KPIs that we see across multiple jurisdictions are things like the number of cases that have gone through a tool, the types of cases, resolution time or velocity, settlement rates, how many cases are moving from, say, a negotiation to a mediation, or how many move from a mediation to go into an arbitration, again, depending on the type of escalation that a certain case might have and a certain dispute tool might have. You've got mediator feedback ratings, arbitrator feedback ratings, again, quite controversial in some jurisdictions and with some services. When people log in, lots of data at the moment coming in about people resolving their cases outside of working hours, even at weekends. How long are they logged in for? The fairness of the process, often that requires quite a lot of rich data from users about their perception about how fair a process has been, how easy it's been, so UI and UX considerations, and the absence of things like data breaches, which are obviously pretty essential whenever an online service is being rolled out. So being able to capture the numbers of users, the numbers of lawyers, the numbers of neutrals, and who's completed sign up and the like, these things give insight into the uptake in an ODR tool. The case breakdown of certain case categories that you might have running through your tool can be very insightful. And what the resolution choices have been, what are the really popular resolution choices that are being offered, and which ones are being taken up there. You can go deeper if you want to, depending on the nature of your service, about how much time people are spending registering their cases, the velocity period, how long people are spending in certain parts of the tool in terms of messaging or video or settlement negotiations. So you've heard a lot from me in the last 35 or so minutes. I'm delighted to welcome Scott on the line and on this session. Now, Scott, for those of you who have joined the call in the last 20 minutes or so and weren't here for the beginning of the introduction, Scott is the president and product visionary of the US-based firm ImageSoft. And ImageSoft is a partner that implements and supports RDO in the US and in Canada. And Scott's been working, I think, in IT for over 30 years and has spent probably the last 20 years, I think, helping courts and attorneys using technology to become paperless. So Scott will have been listening in to a lot of the points that I've been making, but he will have seen it a lot earlier than what I've seen it. So Scott, great to have you on the call. How are you doing?
I'm good. Thanks, Joe. You did a nice job.
Great. Thanks so much. Just kicking off, Scott, in view of your background, I mean, you've been working with the courts for a long time. You work with a lot of courts. Can you talk about courts utilizing ODR technology in your experiences thus far?
Sure. Yeah. So I'll focus. Joe's been kind of, I guess, talking more in broad strokes, a lot about the attorney community into the courts. I'll focus my responses more on the courts. That's ImageSoft is, like Joe said, for the past 20 years, we've been kind of behind the firewall in the courts, helping the courts become more efficient. And recently, we've begun working with Joe with RDO, implementing ODR for the courts. So it's an exciting time. I think there's been a general trend in courts. It's been going on for many years towards simplification. That's just that's one way of saying efficiency. That's one way of saying cost reduction, but simplification is probably the key theme. And we believe, and I think this is being proven out, that ADR, ODR technology is one of the most promising technologies to help courts simplify and help the users of courts simplify. And there's I think there's a lot of trends that, and Joe has touched on a few of them, that affect that, are reasons why the courts are doing that, but I'll just touch on a couple quickly. And Joe referenced this too, there's a general pressure, and everyone knows this is a little bit of Captain Obvious, but there's a general pressure to put everything, to digitize everything, to go online with everything. And why is that happening? Well, as I think most everyone knows, we're kind of living in the middle of a technological and information revolution, and it is affecting every areas of our lives. As Joe mentioned, this simple example of, we used to talk about online banking. It's now just banking because it's all online now, right? It's the same with the courts. The courts now, fortunately and unfortunately, tend to be a few years behind the general market because they're generally steeped in tradition, and we want the courts to generally move a little bit slower. But the time over the last, especially the last couple of years, and then accelerated by the recent pandemic, is the pressure of elected officials to implement efficient technology solutions so that constituents, their voters, can get at data is really, really high. So and a lot of our customers in the courts are elected officials. They're judges in the US. A lot of judges are elected, most judges, a lot of clerks of courts are elected as well. So they feel that pressure. And so that's probably a dominating trend. Another trend, and I'm just going to touch on a couple here. Everybody's heard the term access to justice. I think it's been widely reported. There's been a number of kind of groundbreaking studies over the last, even as long as 10 years ago, about how the courts, steeped in their tradition and their, as Joe said, their Victorian traditions, have not been accessible by members of our society, particularly folks that are under-resourced. And so the courts recognize this. So there's a significant trend to improve access to justice. And we believe, and I think most courts believe, that ODR is, again, one of the most promising technologies to actually increase that access because it puts things online. It really democratizes many of these processes. It doesn't matter, if you have the best attorney in the world or you have no attorney at all, you can participate in an ODR process because the interfaces are built to be consumed by, the general human population and not necessarily legal experts. So those are probably the two biggest trends, and there's a list of about 10 more that we don't have time to jump into today. Joe, I think we've lost your audio again. Can't hear you.
Can you come back to us, Joe? I can't hear you, buddy.
That's all right. If we lose Joe, I've got he had some questions he was going to fire at me, and I happen to have a cheat sheet of the questions, so I can jump in. one of the questions that Joe wanted me to address was common applications for ODR in the courts. And Joe talked about this a bit in his presentation. There has been a trend to go into the high volume cases first. I think traffic has been very popular, as well as high volume civil cases. I'm talking small claims, landlord tenant, credit collection type cases. And the reasons for that are somewhat obvious. They're low hanging fruit. If they're repetitive, they can be more easily tackled by technology. If they're really complex, if they're real high dollar, or med mal or things like that, those cases are much more complicated as far as the participants go, and so they're a little bit harder to handle in an ODR process. But I think the trend is going to be that really every type of case, virtually every type of case can benefit from ODR in some way. A good example of a very complex case is a divorce with minor children. You may not think that that's a great candidate for ODR, but it actually is once the results of the case are known, the case is kind of settled. There's an ongoing number of years where those parents are going to continue to interact with each other, sometimes on a daily basis, and interact with the court. And that's an area where ODR, we've started to see some good traction. ODR tools can help handle those kind of parenting time requests and those miscellaneous requests that might occur in a very complicated case, but are occurring more in a high volume way after the results of the case are published. There is a lot of these, when you look at why are we going into these case types, there's really two reasons. The first is they benefit the court the most, and the court is typically paying for these systems, so they're going to naturally gravitate towards cases that benefit them. But I think the other side of it is back to this access to justice question. If you look at those types of cases, small claims, landlord tenant, credit collection, those disproportionately are represented by under-resourced individuals. So there's also, if you can tackle those types of cases, you can help more people that don't have access to justice or are not on a level playing field, for example, in a landlord tenant case against a landlord who's well represented. So that's a big factor too. But as I said, I think really you're going to see the trend. It's going to start with simple cases, but it's going to expand into much more complex cases because the tools are going to get better. And I think RDO is an example of a very sophisticated tool that is already able to handle quite complex and sophisticated cases, and I think that trend will continue. Joe, you back with us?
Scott, can you hear me now?
We can hear you, sir.
Wonderful. Great. Well, I completely agree in terms of the common applications that we're seeing, but I think just to build on maybe some of the points that were mentioned, that the next stage is going to be doing some of the more complex cases. I mean, having seen some colleagues and former colleagues in the pandemic period doing some quite high value, high complex arbitrations, for example. That's been a very good example. Well, am I still not coming?
Yeah, you're kind of coming in and out. I don't know if you're listening battery.
Okay. Well, I'll get on and ask the next question, Scott, in case I cut out, which was,
Sure.
Can you talk more about the pandemic and some of the changes that it's brought to courts that you're working with?
Yeah, and a lot of the changes, and you mentioned Zoom, are just so obvious they're not worth mentioning here. I agree with your point that there's no going back. These changes, and I'm speculating a little bit, but my prediction is that most of these changes are going to grow roots, and we're not going to go back to an all physical in appearance world that we used to live in. And I think this may be a little counterintuitive, but I think the pandemic is going to probably have a long-term positive impact on courts. And that's, don't get me wrong, everybody, including myself, we feel sorry for the people that have been impacted, the people that have passed away. That's terrible. But the jolt that the pandemic has given, the jolt of electricity to the courts and to other organizations, other industries, is it has wrested them from inertia and has gotten them to move in a positive way in some respects. And I think so. You're going to see, and it proved some things. It proved to the courts that you can use technology and you can change fast, and the process will keep working. And so courts were very conservative and afraid of change. This force in change, I think, can be a positive thing. And I think that, you know, the pace of innovation that we're seeing right now is somewhat staggering, and that pace is going to build an expectation and maybe some momentum going into future years once the pandemic is past. That there'll be an expectation now that we can do this stuff faster. We don't have to wait for, you know, let perfect get in the way of good, as Jim Collins said.
And do you think there'll be a temptation to try and do things perfectly for courts, and therefore it may actually make it innovation and change more challenging than what it might be?
I think perfect is most often used as an excuse not to change. And I think the reasons for not changing are being eroded by this, you know, imperative that they have to change, that we have to go online, we have to serve our constituents, we have to have trials, we have to have hearings, we have to, you know, these things can't stop. The world can't stop because of a pandemic. And so that's the part that's probably going to have a long-term positive impact on the courts.
Absolutely. And as somebody that, you know, you've been serving courts and providing pretty complicated solutions for a while, are there any best practices that have already been established that allow courts to more easily deploy this type of technology that you've noticed? Yeah,
you know, and we've worked on a lot of large-scale projects for courts. So if you're a practice or a practitioner and you've got a small office, some of these will still apply to you. If you're a big law firm with many attorneys, these will probably more apply to you. I think, and some of these are just, you know, kind of IT best practices. And again, some may be somewhat obvious, so I apologize up front for that, but I've got a list of about 6 quick things. You know, just having clear goals and a definition of success going into any project is absolutely an imperative. Having strong executive leadership as part of that, you know, when things, with any type of technology implementation, things are going to go wrong, things are going to come out not the way you expected, there's going to be issues, and you've got to be able to plow through those issues and get to the other side, and you do that with leadership. It starts with, you know, an executive leadership that can step in and say, nope, we're still doing this even though we're feeling some pain right now, but we've got to get to the other side. I would say to any organization, having the right level of subject matter expertise at the table, and expertise with kind of an optimistic, positive attitude. There are cynical expertise, and those people are good for certain things. They're not always good for a large-scale technology implementation. I mean, we don't want to shut cynics out of the process, but we need a little bit of optimism, because there will be difficult times in implementing any system, and you need to be able to plow through that. And the last 2 things I would just say, kind of a relentless attention to detail. That's generally good project management practices and people, and then having, you know, injecting some agility and flexibility and a recognition that, you know, what we thought on day 1 is probably not going to be exactly what we think on day 30. So let's be flexible. Let's let our schedule move a little bit. Let's let our requirements shift a little bit as we get closer to the finish line, and then you'll come out with a working solution, and everybody will be happy.
For sure. We've got a bit of an international audience, I think, that have joined us for this session. May well be because of the promotion that we did for the event. But Many of those folks that are on the call will be experiencing courts in different jurisdictions, Scott. And if you were to say, you know, in the next 3 to 5 years, what do you think good will look like from the perspective of the courts?
Good question. So, I think, one thing that's I think these trends I've talked about are really putting an exclamation point on is the cloud is here to stay, right? It is a much better way to implement most technology solutions. It is much more secure than most on-premise solutions, and it can be done much more quickly. I mean, Zoom is a great example of a great cloud platform, and none of this would have been possible, the reaction to the pandemic, if the cloud didn't exist and if Zoom weren't a cloud-based product. So the same thing applies to ODR. So I think, first and foremost, the just an awareness and acceptance that our data is going to be in the cloud. It's going to be actually more secure than we could ever make it on our on-premise system, unless you didn't give anybody access to it. Obviously, you can put a very secure system in a locked room without connection to the internet, but that doesn't help very many people. So that's probably the biggest thing. And I think, the mobile revolution that we've all it just came upon us. I mean, we look back 5 years and, these smartphones did not exist, and now we're all kind of attached at the hip to these things. And obviously that affects all of the participants in any sort of court. And that's really driven a lot of the, information explosion that we talked about earlier and the access needed. So I think continuing to respect those, general trends that are really happening, not just in the United States and Canada, but around the world, and preparing for them, this kind of new reality. And I think I look at it positively. I think it's very exciting. I think it's going to help a lot of people. And that's kind of, I guess, my glass is half full perspective on all this.
Yeah, for sure. And given your background, I know we're running out of time, but I thought I'd ask you about artificial intelligence, because having worked in the sector for many decades now, you probably saw the shoots of AI well prior to most of us. But how do you see that playing out in online dispute resolution platforms and courts going forward?
Yeah, well, first of all, so when I graduated from computer science in 1986, we talked about AI, and what we call AI today is very different. But I think there's a place for systems that are self-improving. Now, whether you call that artificial intelligence or not, technically, the way AI was defined 20 years ago, it's not actually a learning machine as was originally posited. But I think there is what we call AI today, where systems can actually improve themselves based on data that they're collecting, that can improve outcomes based on data that they're collecting, or based on previous processes that people have run, I think is real. And I think it's going to be an exciting evolution of ODR technology. And there's many examples where, there's some things that have been tried that have failed. I think they tried to use the automated judge a few years ago in courts, and that was, I think, for criminal cases, that was generally considered a failure because of the because the data was actually presenting some biases that were unacceptable. But I think for these types of cases where we're dealing with civil cases, and AI can help people understand maybe the statistical likelihood of success of maybe an offer in a negotiation or a mediation, I think that's very valuable. And that statistics can obviously be driven from data, and that is a form of intelligence or automation that I think this technology is gonna move towards more and more in the future. So it's an exciting future but I think we're pretty early in this. So we're I don't know what are your thoughts, Joe? I know you guys are on the leading edge of this as well.
Yeah, I think I'd agree with all of those points. Putting my sort of legal hat on back for a moment, which tends to be slightly more conservative than the entrepreneur's hat. But one of the things that we need to get right is in any platform is having a clear distinction between what might be considered as advice and what might be considered as information. So the notion, and this has been postulated in a number of jurisdictions. And in fact, I think nearly 2 years ago we were discussing this very concept with some of the innovators in the Singapore government, which is, does one, when they're giving some information to an unrepresented litigant, which could just be seen as information, actually start to become almost constructive legal advice because they're not represented. They're going to place a lot of weight on it because it's come from an independent platform or a branded government platform. And therefore, does one need to be really careful in terms of how they couch that information? I think the answer is yes, one does have to be careful. But I'm also very excited about some of the insights that one can draw from data and being able to take, perhaps even at a very simple level, starting some of those technologies out in the lower complexity cases might be a really great starting point, and then perhaps we can scale from that point on. But Scott, that's probably, you and I probably need another hour to talk about artificial intelligence, I think. And Linda has very helpfully just appeared, probably just to prompt me that we've come to the end of our time. But thank you so much, Scott, for joining us. Really appreciate it. Thanks, Linda, for having us. And I hope folks have enjoyed the session that we've put on today.
Yes, thank you, gentlemen. Very much appreciated. We're so grateful to you for being with us today. Let me remind folks to please submit an evaluation. The link to the evaluation form is in the chat. The next event is an exhibit hall break. So you'll have an opportunity to go over and visit with some of our exhibitors and talk to them about their products and what their products will do. And then finally, I just want to remind you that tonight we have a special social activity at 8 p.m. Eastern Time. There will be a presentation on negotiating air, arts, and life with Drea Weber. She is an aerialist, and if you click on the link, you'll actually go to a short video of her demonstrating some of what an aerialist does. So I'm pretty excited about it. I've never seen one before. Again, gentlemen, thank you so very much for joining us. I'm gonna leave the Zoom open for a little bit for people who want to click on the links, but you are welcome to leave us if you'd like. But thank you.
Thank you very much.
Thank you, Linda.
Take care.